I would almost heighten the flag of just caution, caution, caution. What makes a good artist is the ability to create.
Welcome to another exciting episode of Sandile Hlangani podcast, where entrepreneurship meets innovation. I'm your host, Sandile Hlangani, a tech journalist passionate about telling stories of businesses who are shaping the future of work. So joining us today is Werina Griffiths, partner at Adams & Adams, who will be sharing her expertise and insights on the generative AI content. So Werina, thank you so much for making time to join us. We really appreciate that. Just for the benefit of our viewers and our audiences, what is AI generative content?
Sure, Sandile, thank you. Thank you firstly very much for having me. What is AI generated content? Maybe let's take it one step back to understand AI generated content and just touch briefly on what is AI. Because it's a very topical word and it gets thrown around a lot, but do we really understand? And quite simply put, and I'm not going to try and proffer a scientific or a technical explanation, but at a very high level, AI, there are different forms of AI, right? So it's not just one thing, machine learning and deep learning and all these foundation models, but it is really any system that can perform or match, even exceed, I guess, human intelligence. So where you would traditionally have a human, and the human would receive an instruction. In carrying out that instruction, it often results in something tangible, so output content. What happens with AI-generated content is we take the human author out of the picture, and it is replaced or augmented by an artificial intelligence system. So what happens is exactly the same process. There's an instruction to the AI system, and it generates content, but in the absence of any human being. So we do not have a human author or a human creator involved in the process of AI-generated content.
That's very insightful. Can you just share with us the current state of ownership when it comes to IP?
Sure, a little more difficult to answer, but I guess the first thing to understand is that just as the AI technology has so many different facets and layers and intricacies to it, quite a complex subject field, right? So IP or intellectual property is the same. It's a very technical subject. You get various forms of different intellectual property rights. So you get the trademarks and the patents and the designs and the copyright. So that's the first thing is the different forms of IP right. And then the second thing is that intellectual property rights are territorial. And what that means is each country or jurisdiction has its own laws that are applicable, and it will tell you what the extent or the nature of the right is, what the extent of the protection is. So there's not a blanket answer is what I want to start off with. There's no one size fits all here. We do have to look at it as a case-by-case basis, always. When we talk about AI-generated content, so the example that I've just explained to you, where an instruction is given and content is generated. The first problem we have in terms of IP legislation is the fact that we do not have a human author. Typically, all of these IP rights, traditionally at least, would have had human authors, and the legislation was, drafted in accordance with that. Now we do not have a human author, and things become a little more difficult. There is certain pieces of legislation, in some countries that expressly exclude cases where there are no human authors, saying that there will be no protection in those circumstances. If I bring it home to South Africa, that would be the case, for instance, under our Patent Act. The wording there lends itself to an interpretation that it will require a human author in order for there to be protection. But if we look at what these AI platforms typically generate, so thinking about the foundation models that we have now grown accustomed to, you know, the ChatGPTs of the world, they are generating text, they are generating images. Those kinds of content is typically protected under copyright. So if we consider copyright protection in the AI generated content, again, we look to the author. That's the starting point under copyright protection, but here we do not have a human author. Luckily for us, we are in a slightly beneficial position in South Africa where our act, much the same as the UK, provides for circumstances where works are generated or created by computers. So it is defined as a computer-generated work. That means, and we have had one case in the SCA some time ago, it involved a computer program, but nevertheless, where the court recognized that there can be instances where works are created through computers, meaning there is no human author, and we can still, it would still be protected under copyright law. So that is a possibility, at least under South African law. We know that even if we do not have a human author, we could have content that is protected. The question then becomes, well, how do we identify that author? And the Copyright Act again guides us, and it tells us that the author of computer-generated content is the person who made the arrangements that were necessary for the creation of the content. So you can see that it's that's the test, and we will have to apply the test in each case as it comes up. You know, sort of a factual inquiry on a case-by-case basis.
So how are courts addressing the application of intellectual property law to generative AI?
Look, that's again a difficult question to answer right now, because at least locally we've not had the opportunity to have it tested in courts. There is a plethora of cases pending in other countries. United States, there are more than a dozen specifically infringement, but nevertheless copyright focused inquiries in lawsuits, pending lawsuits there. There's some in the UK. So the topic is enjoying a lot of attention worldwide, but we have not seen a whole lot of decisions yet. These things are still pending, and everybody's sort of still grappling with the issues. However, having said that, what we have seen and what's quite interesting is coming out of China, a similar assessment that was done there in terms of AI generated content. Is it copyright protected? Where the court found that it's not the absence of a human author so much as we would have in South Africa, where we do not have a human author, but there could still be recognition for protection on the work. The same sort of result there. And then the question becomes, so once you have a situation in which you have a work that can be protected and you can identify an author, the question then becomes one of what we call originality. So it becomes a test of what exactly did the author do, and was it enough to justify protection? So we talk about the originality test, and it's about the skill and the effort, the intellectual input, the creativity that was spent by the author in the creation process. Coming back to the case in China, that's the test that the court had to apply. And it specifically looked at the prompts. So with these large language models, you need to provide a prompt, and it then reacts on that. So the court specifically looked at the prompts that were provided by the user, and ultimately found that, so it involved a text-to-image generator in that case, so it was an artistic work that was created, looked at the fact that there were quite detailed prompts provided to the system in terms of the characteristics and the traits that the user wanted in the character ultimately designed, as well as the angle of the shot, the pose, and all of that sort of thing. And the court found that was enough intellectual input to grant copyright protection in that work. If you look at the US, what has happened there in a similar sort of assessment around artistic works that were created through text to image generator. First, the Copyright Office in 2 different cases, and then even a district court, all found that in the absence of a human author, no recognition can be given, no copyright protection can be given to works that were generated through those AI platforms. So to answer your question, again, you can see it's sort of, I want to say contradictory outcomes, but certainly not the same outcome in every jurisdiction, as I suspect it would be going forward. And it really comes down to what are the facts before the court in each case, and which country's laws are we applying, and do they make provision for human authors or not, and do they make provision for computer-generated works or not. So not a standard answer that I can give you on that one, unfortunately. And we're still waiting, as I said. In our country, we have not yet seen anything.
So how do you think AI-generated content will impact the concept of authorship and creativity?
Sure, Sandile, that is when it comes to AI-generated content, and we are talking about these types of content like the text and the image creation. That I think that's the platform that most users are maybe engaging with, and that could assist greatly in especially administrative type tasks in the workplace. So I would imagine that is the platform that is sort of enjoys most practical application, put it that way. And when we are considering those platforms, we have to accept and recognize the fact that these AI systems firstly have been trained. They need to be trained, meaning that there were vast amounts of data that were fed into these systems as part of the training process. So there was potentially proprietary material that have gone into these systems, and we have already seen in the United States that there are a number of infringement claims from proprietors saying, our works, our novels, newspapers, even music have been used without our authorization. So just realize and recognize the fact that the data sets that were used to train these models may have involved an infringement of copyright at the outset. Then material gets created following an instruction to the AI. In doing so, we expect these systems to work independently, to function independently. They are often referred to as black box systems, in that not even the developers themselves necessarily understand the creation process. But it is very possible that work that is generated, much like a human, we said at the outset we've replaced, but it is, in the place of a human author, we have the AI system creating. Much as you had with a human, you can either create of your own, and come up with something truly original, or you could look for some inspiration and or even reproduce from something that's already existing. The same holds true here, where you could end up with an end result, output content that may be substantially similar to something that's already in existence, and specifically drawing back from the content that it was used to train on. And what all this means really at the end of the day is firstly that the content that's being generated may not be unique to your result or to your instruction. It may very well be the case that the platform or the system generates a similar result for someone else, which creates a risk if you need to own that content, if you need to be in a position to commercially exploit that content. If you are using something in the hopes that it's exclusive and would position you in the market, and the same content is generated for someone else, that could put you in a very difficult position. Then comes the question, should that happen and you wish to enforce your exclusivity, can you do that? You will only be able to do that if you own IP in the content generated. And if we come back to the discussion we've just had, and there certainly are circumstances in which you may very well not own IP in the content generated by an AI system, then that in itself creates a risk. You will not be able to enforce, you will not be able to retain exclusivity in the content generated. And to bring it back to sort of the traditional purpose of copyright protection is to put the creator in a position of exclusivity in order to exploit commercially. We wish them to make the creators to make money from their creations. That's what it's all about. And if they can sustain themselves through their creations, then they will continue creating. So it is very important if it is content that is generated and it's something that you wish to own exclusively, that you wish to be able to exploit commercially, and it therefore something that it is important than your own IP, that you maybe be a little more circumspect and a little more careful in deploying AI systems to do that. And then another risk, is that realizing that there are different platforms, different systems available. There are those systems that we call closed systems. In other words, they don't continuously train on information or data that is being put in by the user specifically. But then you've got your bigger, your more open systems where anything that you provide to the system, it is then digested, used for training, ongoing training purposes, and even disseminated or to other users. So if you are working with proprietary information, proprietary data, that you be very careful in terms of what kind of system you allow that to go into, to be used by users. So I would say, something like looking at terms and agreements of any sort of system that you implement in your business or organization, even quite frankly for personal use. Look at what the terms and conditions are of those platforms. Try and govern and mitigate your risk, reduce your exposure as much as possible. Have policies in place around the use of AI in your organization. And then, as I said, just give consideration to what it is that AI is being used for, and if it is something that is important to own exclusively, perhaps approach with caution.
So having said that, don't you think that these AI-generated systems can then be considered as co-authors or rather collaborators in the process of creativity?
I don't think that the issue will come down, or the answer rather will come down to one of co-authorship, simply because the AI system itself cannot be an author in the true sense. A creator, yes, but when we're talking copyright law, author has a very specific meaning, and it's an extremely important one because the general rule is that the author is the first owner of the copyright. There is a distinction to be drawn between those two. So you have the author, this creator, and then you've got the owner of the copyright, and it's the owner of the copyright that really holds the golden goose. So not one of co-authorship, but again, when we look at the definition of author of computer-generated work, we're looking for the person who made the arrangements necessary for the creation of the work. Now, the interesting question that arises there is exactly who is that person or persons who made all of the arrangements that were necessary for this end result to come into existence. I can foresee an argument that this creation process was not possible without the developers. So too, this creation process was not possible without the user who conceptualized. So who is it? And again, it will always come down to a factual question, but I think if we consider the sort of general large language model ChatGPTs of the world, the distance between the developers and the end result, the content generated, to me is just so far removed. They wouldn't even be able to foresee what all can be created. That to ascribe authorship status to them, to my mind, is perhaps not the way to go. In my opinion, it would be, there's a far greater chance, put it that way, that the user may be considered the person who was responsible for making the arrangements for that work to come into existence. And in that scenario, the user becomes the author of that work. So it's not a co-authorship, it is a true authorship position, which then puts you in a good position, the author being the first owner, unless any of the exceptions apply. But that basically brings our user into the position of authorship. Where it does become interesting is, you can, not all of these AI systems are these foundation models where you just instruct and, generates a result. Some of them are tools that enable AI development. Just thinking of, for instance, Azure of Microsoft. So those tools can be used to develop, let's say, AI chatbots, right? And they need to then be developed, they need to be trained with your proprietary data to then perform a specific function, and then there's a user on that system that instructs the AI, generates a result. So now you have a situation, or you could have a situation where the developer of the specific AI tool and the users thereof all sit within the same organization. And then, unscrambling this egg might be slightly easier in terms of answering the question of authorship and ownership. But yeah, so no straight answers.
So how can companies balance the benefits of using generative AI with the need to protect the IP laws?
I think the step one, for me at least, would be recognizing or identifying what the AI is being used for. If we need to balance those interests, we need to give recognition to where it is important to own IP in the content that is being generated. If, as I mentioned earlier, it is something that would be important for the user to be able to commercialize, or for the user's employer to be able to commercialize, again, one needs to be very careful in terms of which systems you use to generate such content. Perhaps rather than give consideration to using the AI system, perhaps in planning phases or stages, when you are bouncing around ideas, sort of the foundation of getting to where we want to be. But when it comes to the actual creation process, that consideration be given to the more traditional way of doing things, to ensure that we end up with a product that we have more certainty, at least for the moment, that we can protect that copyright, or protect that content rather under copyright. Sure, that is a little more difficult because, as I said, it's so difficult to know what exactly the creation process is inside an artificial intelligence system. So as much as one can provide input in the form of prompts, what is ultimately generated is not the work of the user, put it that way. As I mentioned to you, the test is going to come down to one of originality. It's going to come down to, did the user, did he or she do enough, expend enough, whether it's intellectual or creative skill and effort in arriving at the end result. My personal opinion is 1 prompt, 2 prompts probably shouldn't cut it. Perhaps not enough to bestow that end result, that work with the label of originality that is sufficient for copyright protection. But in saying that, we know that the creation of prompts in themselves is becoming a bit of a science. We now get prompt engineers, where people are specializing in being able to prompt AI to get high quality results faster. So there might very well be situations where what the user is doing in terms of prompting and guiding and correcting and may be enough that what we see in the end result may very well be sufficiently original for copyright protection. That is possible.
That's very interesting. So how do you then see AI playing a role in the IP law?
Well, look, right now we're sitting at this crossroads where we're trying to figure it out, right? And we're trying to figure it out because we are having to deal with legislation as they were drafted. We are trying to apply existing legal principles to a whole new set of facts, technology that wasn't in existence certainly when many of these pieces of legislation were drafted. So going forward, I certainly, and I'm pretty sure I'm not the only one, but would like to see more certainty. You know, it is quite difficult at the moment to advise clients in a certain or a more certain way, one way or the other, because we have all of these grey areas and all of these open questions that have not been answered. So either through interpretation through the courts, you know, and application and guiding us in terms of what all these provisions mean when we start applying them to the technology. But best case scenario would, of course, be amendments to legislation in order to cater specifically for this type of technology, to give us clarity on who would be an author for this type of work and who should be the owner if that content should be owned at all. As I mentioned earlier, a lot of courts all over the world currently grappling with these rather complex questions, but hopefully ultimately that means we will move in a direction where the rules of play will become a little more clear to everyone.
So can you think of any international harmonization efforts that you think we need to address this, just to avoid global implications?
Not really at that level, to that extent, no. So, you know, we see the United States, it's probably at the forefront currently in terms of, you know, the lawsuits and what is happening, the considerations by the courts, the fact that we have seen some decisions in that jurisdiction, and there is also a lot of talk, really a lot of debate at least happening around potential legislative changes. But that is sort of on US soil. In Europe, of course, you know, there we have, under copyright law at least, the countries each still have their own legislation, but there are European directives that sort of give guidance, but again, it's for the countries at national level to interpret and apply. So some level of harmonization, but not you know, really a measure of autonomy remains. And on the African continent, we don't even have it at that level. We do have some regional systems. OWAPI would be one such example, which is a regional system for about 17 West African countries. But apart from that, not really harmonization. We have seen the African Union has adopted an AI policy, a continental AI policy. Yes, so that serves to guide sort of all of the African countries. But as with most, if not all of these policies that I've seen, the policies on the regulatory front, it's very focused on, you know, the issues of ethics, privacy and security, job automation, job losses, that sort of thing. It's very much focused on the social and economic development front. I'm yet to see any kind of policy seeking to deal with, you know, what about ownership of intellectual property rights. So I guess the short answer to your question would be no, not really.
So as we wrap up this conversation, what advice would you give to creators and companies?
To creators, I would almost heighten the flag of just caution. You know, what makes a good artist is the ability to create, and create originally, and originally to that individual's personality. That's where it comes from. It's when it's genuine, it's when it's original that it really matters, and it receives that uptake and that support. And I again, as much as this technology can assist on so many fronts in speeding up that process, in assisting with the sort of research and development side, the first phases, I would hate for creativity to go lost in the process. Real, true, genuine, original author creativity to be retained. So I guess with that I'm saying again, be very cautious in terms of the extent to which reliance is placed, I guess, on the technology in the place of original human creativity or originality. The technology has its place, of course it does, and like I said, it really can play a significant role in enhancing, but creators continue creating themselves.
So thank you so much for watching this another episode of Sandile Hlangani podcast. If you are inspired by these episodes, please don't forget to subscribe and join the family. Until next time, keep grinding, keep building, and keep shining.